Welcome back to Legal Action. We're here today to discuss mortgage foreclosures, and I'd like to take this opportunity to introduce our panel today. We've been talking with attorney Stephen Bashaw, and Steve has told us at least a little bit about what happens in the beginning of the mortgage foreclosure process. We then were talking briefly with attorney Patrick Williams, and Patrick generally represents lenders, and Pat was giving us some information from the lender's perspective. And to my left, I have attorney Kent Gertner. Kent represents people in bankruptcy proceedings, and while that might be an option for some folks in a mortgage foreclosure, I'd like to turn back to Pat for a few minutes if we could. Pat, when we went to the break, we were talking about from the lender's perspective, that is from the bank's perspective, how important it is that the borrower actually reach out, and you said make some meaningful contact. Can you tell us or define for us what you mean by meaningful contact with the lender?
I think it's important for the borrower to understand that the lender is not looking to take their property. The lender is looking to see to it that the delinquency is cured and that the property is taken off their foreclosure roll. So therefore, they are in a process where they want to see what the borrower can offer in terms of a repayment plan that meets the expectations of the lender and meets the expectations of the borrower. And by that I mean that there are promises made by the borrower that are promises that can be kept. I think it is unfortunate but all too frequent where a borrower will make a representation that the money is going to be there on the come, and that they know that they'll be able to make a $5,000 payment in 30 days. The lender will hold them to that, and then when the payment isn't made, then that puts that borrower in a bad situation because the borrower has made a promise to that collector and that promise hasn't been kept. Generally, the lenders will work with a payment plan that is intended to retire the delinquency within a period of usually 6 months to a year. A year is probably at the outside, and that usually involves doubling up on payments. And as Steve Bashaw indicated, they're going to want an indication that the payments can be made and that the circumstances that have presented themselves have somehow been changed such that the payment is a reasonable expectation. If that's the case, that's the end of the discussion, and the file usually never comes to me.
I see. So in other words, to go back to our scenario, if I am a homeowner and I have in fact lost my job through no fault of my own, and I go to see Steve, and Steve then gives me this advice, and Steve would actually contact you, who represents the bank or the lender, and it sounds like if I am able to get a new job, if the problem that caused the delinquency to begin with is fixed, if I get another job, for example, then the lender would work with me in repaying the past due debt. Is that right?
As I say, the lender is not interested in having what they call an REO, a real estate owned, on its books. They do not like the delinquencies. They will generally make every effort to try and work with the borrower within reason. When the reason starts to fall away,